For joining us. Now, the presiding judge says the trial judges made a number of errors in rejecting Gbagbo's request for release, now including failing to consider his health and the length of time he has already spent in detention. What's your view on this argument?
Yes, thank you for having me on the show. I think the appeals chamber did not find it necessary to deal with conditional release of Mr. Gbagbo, because the question of conditional release could only be meaningfully addressed once the question of continued detention had been reviewed by the trial chamber. What we must note is that the ICC statute itself provides that a chamber can review rulings related to release and continued detention of a person in its custody, and it may modify that ruling if it is satisfied that there are changed circumstances that so require. Now, a review that is necessary, and in this particular case, there had been at least 10 reviews of Mr. Gbagbo's detention at the ICC. It should be based on current circumstances which underpin the detention itself. So what the appeals chamber was asked for, requires of the trial chamber, is to look at, is to review the entire petition, to review the circumstances and see whether there are any changed circumstances that would then require that he be conditionally released. So that is the extent of the decision of the appeals chamber this sentence.
Now, Allan, rights activists have argued that Gbagbo is a flight risk. At this point in time, is he really a flight risk? Because what we saw earlier today is somebody, a former president who looked frail and who didn't seem to understand what was really going on in the court. Is this an act from him was it an act from him to sort of get the judges to change their decision? But they made it a fact that pointed out that it is a unanimous decision. Is he a flight risk?
That's part of what the trial chamber needs to review, and this is what is being directed by the appeals chamber today. And what, in this particular instance, the appeals chamber found was that the trial chamber made a mistake in considering the advanced age of Mr. Gbagbo as a factor that would increase his desire to abscond, rather than it being a potentially mitigating factor for him not absconding. And it also paid attention to the question of his health, but says that the trial chamber needs to consider it in relation to conditional release as well as in relation to the assessment of his risk, being a flight risk or such other factors. But so ultimately what needs to happen is that the trial chamber needs to look at the changed circumstances and not make references to its previous decisions without really looking at whether there are changed circumstances, new circumstances in the totality that underpin the detention of Gbagbo. And so that's what we will wait to see the trial chamber make a decision on.
Now, Allan, you've spent a lot of time doing research on this matter, and former President Laurent Gbagbo has pleaded not guilty to charges of crimes against humanity. Now, if he should indeed face these charges, do you think the courts have spread the net wide enough? Is he the only one who has to face these charges, or are there other people that also need to be brought in and face the same criminal charges that Laurent Gbagbo is facing?
It's a good question. It's a question that plagues the international justice system as a whole, and it's a question of victor's justice. Gbagbo is currently a co-accused with Charles Blé Goudé, who obviously was a supporter of the former President Gbagbo. So one of the criticisms that the ICC has faced in the situation in Côte d'Ivoire is that it has only focused on the pro-Gbagbo side of the conflict, but has not yet addressed itself to the pro-Ouattara side. We do know that the Office of the Prosecutor has said that it will address itself to the pro-Ouattara forces, so that then both sides of the conflict would face a form of accountability. But it's a similar problem that also happens in Côte d'Ivoire itself. And the president Ouattara has called for accountability, and in the period between 2011 and 2014, we have seen only trials on the pro-Gbagbo side and not the pro-Ouattara side, including the trial of the former First Lady, Simone Gbagbo.
Now, Allan, let's say he is given interim, he is released on an interim basis. Now then, whose custody does he go into? Whose responsibility does he become?
It's an interesting question. I don't think the court has had to address itself to that particular question of an ongoing case where there has been a conditional release. But given his medical condition, which his defense counsel is asserting as reasons why he should be given conditional release, we may speculate, but perhaps he will remain under the ICC's protective custody, but certainly it would be inadvisable for him to go back to Cote d'Ivoire at this point.
Allan, is
the trial chamber finding his for his conditional release.
Now, just to get clarity, is his medical condition a genuine condition?
That is not known. It's an issue that the trial chamber has got to address itself to, and that's what we shall wait on.
Now, in addressing that issue of the fact that they say he's really, really ill, would the chamber go as far as doing their own medical tests or getting their own doctors to medically check him to ensure that he is really ill in terms of mitigating with regards to the case?
It would be prudent for the court to have its own assessment of his medical condition.
Now, what do you think Gbagbo's chances with regards to the court giving him what he's requesting for the interim release, and can he further challenge a possible rejection of this appeal?
Well, under the ICC statute, as I mentioned, the review of detention is something that happens periodically. And as long as there are changed circumstances, then a chamber can make a finding against its own previous ruling. And so it is possible to make appeals to decisions of the chamber. As I said earlier, there have been 10 decisions of the trial chamber in this regard of his conditional release and a review of his detention, including one appeals chamber decision in the past. So it is possible that he can appeal a decision of the trial chamber should it find that he should not be released. But of course, the appeals cannot be in perpetuity. The questions that need to be raised, and this is an issue that the prosecution as well as the legal representative of victims raised in this particular case, is that there had been a repeat of the same arguments in the previous decisions that the trial chamber has addressed itself to, and the appeals chamber will not entertain this, neither would the trial chamber, on the same questions that it has previously decided on.
Now, Allan, you argued not long ago that if incumbent Ivorian President Alassane Ouattara decided on a presidential pardon, now this is in the spirit of reconciliation, it would be difficult to see the rationale behind conducting the trial. Now, is there still room for such a pardon?
We need to understand the process of reconciliation, that it is not a one-time event. It cannot be stated that we shall now enter a period of reconciliation and therefore all other processes of dealing with the past come to an end. That would be it would be a travesty of justice. What needs to happen is that there needs to be complementary mechanisms within a transitional justice context that would assist a state that is in a post-conflict period to deal with the past. So in Cote d'Ivoire, for example, there was a Commission for Dialogue, Truth and Reconciliation, which was established to identify root causes of the conflict and also to address certain issues with respect to victims' rights. And this is meant to be in complementarity with accountability mechanisms locally as well as internationally. And all these must work together. A pardon cannot be issued for international crimes, for example, and that is a standard that is accepted in international law. So statements on pardon cannot prevent accountability for international crimes. They need to go on, but we also need to understand that reconciliation is a process.
Now, how is the ongoing trial affecting social cohesion in the Ivory Coast?
It's a challenge. The report of the Commission on Dialogue, Truth and Reconciliation, it was completed in 2014, but the government has yet to make this a public document. And we also think the challenge that I mentioned earlier of accountability only for pro-Gbagbo forces, which isn't correct. There needs to be accountability on both sides of the conflict. So these mechanisms that are supposed to assist Côte d'Ivoire to deal with the past are not fully functional, and therefore social cohesion, reconciliation is not being achieved. As I said, it is a process, and they've started on the journey, but a lot needs to be done in order for that path of reconciliation to lead to social cohesion.
Now, Allan, in wrapping up, what do you make of former South Africa's President Thabo Mbeki's argument that the court should play a balancing act between retributive and reconciliatory justice in Gbagbo's case? Now, he argues that if retributive justice wins, the Ivory Coast may never find peace.
I think his statement is true to the extent that when we look at retributive justice as the panacea to addressing the past, then we err in assisting a post-conflict state in dealing with the issues of the past. There needs to be a whole range of mechanisms that need to complement each other in order for that state, and in this case for Côte d'Ivoire, to effectively deal with the past. So we have spoken about the International Criminal Court, but there needs to be a strengthened national criminal justice capacity in order to address international crimes as well as other crimes in Côte d'Ivoire. But also there needs to be other processes that support truth, reconciliation, reparations for the victims of crime. So all these need to speak to each other, they need to work with each other, and they need to be locally owned. Once all these are in place, then it is easy for Côte d'Ivoire. It's perhaps easy is too simple a term to use, but it can assist Côte d'Ivoire to find its way to peace.
Allan, thank you so much for joining us. We'll have to leave it there for now. And that was Allan Ngari. He is a senior researcher in the Transnational Threats and International Crimes Division at the Institute for Security Studies and leads the work on international criminal justice at the ISS. He joined us via Skype from Pretoria.